folks, I'm doing something a little bit different here. Your book on this next chapter is not strong on employment discrimination rules and things like that. So I developed a slideshow for another class here, just to give them a good background in employment discrimination. So what we're going to do is, before the break, we're going to talk about these slides. We come out of the break, we'll very quickly talk about the slides that came with the textbook to give you as much coverage as we can. Okay? So just so you know why you've got slides up there that are obviously not key to this textbook, because they're not key to the textbook. So, in any event, you see the copyright on that. Claremont Management Group is me. That's the name of my consulting firm that is famously me, myself, and I. So, okay, as we talked about employment at will a few minutes ago, we said you have a situation where many employees are protected for a lot of different reasons. Under the employment discrimination laws, we have quite a list here. Most of you are familiar with the list. And it goes on and on. Gender, you know, pretty well known. Though most of the gender discrimination cases that I've seen, I've handled over 2,000 employment discrimination cases, and the majority of them today that involve gender involve sexual harassment. Rather straightforward. I'd say 2/3 to 3/4 of all gender discrimination complaints are based on sexual harassment. One thing that people miss, and it's so interesting, I was presenting this to the undergraduate class just a couple weeks ago, I almost never see an old Civil Rights Act case. The old Civil Rights Act is 1866. It was designed very specifically to protect the rights of black persons in the United States. Following the Emancipation Proclamation, which President Lincoln announces during the Civil War, blacks are free. That didn't help them very much in terms of economic freedom and things like that. And so the Civil Rights Act 1866 is specifically to cover the right of black persons. And again, it doesn't say this as race, but it was basically one minority we were dealing with at that time, technically speaking. And so what they go and they say, if you have a contract, and they decided that the 1866 Act covered employment because employment is in a form of a contractual relationship. So you can use the old Civil Rights Act in an employment setting. And you can also use it if you're housing discrimination or whatever. So it's a fairly broad statute. One of the advantages of it is it has no minimum number of employees, and it does not require to go through the EEOC. And you can go directly to court. Now what's interesting about this is I was called in as a consultant for a pretty well-known nonprofit organization here that was sued under the old Civil Rights Act just about 6 to 8 weeks ago. And the reason it's interesting to me is we never see it. It's like people don't even know it exists. It's out there, but people go to the EEOC where they don't need an attorney, and hopefully they can negotiate a settlement without going to court. So in this case, they're suing this very nice nonprofit for millions of dollars. It's never going to happen. So I don't know if the case will get dismissed or not, but it's. I would have helped them with the case. I don't litigate. So I would have helped them with the case if it wasn't in litigation, trying to help them negotiate and see if we make it go away. But it's a very sad situation. It's essentially a bet the farm situation. The nonprofit organization has so little in terms of resources that if they do not have employment practices insurance, they probably will be forced to file for bankruptcy in order to deal with the case. But if you're not familiar with it, one of the areas to handle employment cases is called EPLI, Employment Practices Liability Insurance, because regular insurance does not protect your business from suits by your own employees. So you must buy separate insurance for that, again, EPLI insurance. And it is a common package in most standard business policies today include EPLI in the package. So last time I talked to the organization, we worked with them over a weekend. Of course, at no charge, it's a pro bono exercise to try and help them understand the case, what their risks and liabilities were. There were some attorneys that were recommended. We also looked up and made some attorney recommendations. But again, the problem is just the cost of hiring the attorney would probably exceed their financial ability. And that's without knowing if the case is going to go through the federal courts or state courts for 2 years and stuff like that. So I'll know if they got out okay because they're pretty high profile. They put on some big events, and if we don't see the events next year, we'll know they didn't make it past the lawsuit. So I think a tough area. Most of us are more familiar with the Civil Rights Act of 1964, famously pushed through by President Johnson following the assassination of President Kennedy. The law was actually drafted at the direction of John Kennedy, was in the works when he is assassinated. Johnson, who was famously not the friend of any minorities, he wasn't a friend of too many people, frankly, it's interesting because he says to himself, I, having just dropped into the job, cannot win the election of 1964 without support of black voters. So what can I do? And he did a masterful job. In fact, there's different books and things about it. But he did a masterful job of putting a coalition of Republicans and Northern Democrats together to pass it over the Democrat bloc that controlled the South and that opposed the Civil Rights Act of 1964. So it's very interesting because it's not the parties. The parties didn't line up the way a lot of people hear it today, but clearly it was Johnson's only finest hour, as far as I can tell, was pushing through this beneficial legislation. And it did take a while for industry to realize that it was a real law, it was really going to be enforced, but it established the EEOC, and again, it's been added on to. Basically, employers with 15 or more employees are covered by it. Public entities are covered automatically. Employment agencies are covered automatically regardless of how many people it clicks. So I'll tell you what, we're running a little